Good afternoon, everyone, and welcome to our monthly meeting of the Board of Zoning Appeals. At this time, I'd like to ask everyone who's able to please stand and pledge allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I will now call the meeting to order. Please silence your cell phones if you've not already. Much appreciated. For those of you who do not have a copy of the agenda or who are attending for the first time, we will concern ourselves with the cases that are on consent. These are cases that we have been reviewed by the board and by the professionals of the various departments in the county, and to which there is no known opposition at this time. We've discussed these in our work session, and certain staff comments and stipulations have been made, and we do not anticipate any further discussion is needed for this decision. So as we go forward, the county's zoning division matter, Mr. Peterson will read each case into the record. Mr. Peterson will ask you to raise your hand as your case is called to signify you're present. If you're here in opposition to a case that is currently on consent, Mr. Peterson will ask you to identify yourself as the case is read into the record. We will then pull that case off consent and hear it as part of the regular case agenda. We will then vote on all of the cases still on consent at one time. Once we have approved the cases on consent, we will move to our regular case agenda. With that, Mr. Peterson, it's all yours.
Thank you. Before we begin the consent agenda, there is one case on today's printed agenda, and this case has been withdrawn without prejudice and will not be heard today. That's variance case V75, Cole Isbon. That case has been withdrawn without prejudice and will not be heard today. And with that, Madam Chair, the board is ready to start the consent agenda. Cobb County Board of Zoning Appeals, variance hearing consent agenda for July 12th, 2023. First case on consent is variance case V68. Del Cidio Joao da Silva Jr. request a variance to number 1, allow a fence to be up to 8 feet in height when in front of or to the side of a house in a residential district. Number 2, reduce the side setback from required 10 feet to 2.9 feet adjacent to the south property line, and that is existing. Number 3, increase the maximum allowable impervious coverage from 35% to 66.45%, and that is existing. Number 4, reduce the side setback for an accessory structure under 650 square feet for an existing approximately 160 square foot outdoor bar, required 10 feet to 0 feet adjacent to the south property line. Number 5, reduce the side setback for an accessory structure under 650 square feet for an existing approximately 273 square foot shed, required 10 feet to 2.7 feet adjacent to the north property line, and that is existing. And number 6, reduce the rear setback for an accessory structure under 650 square feet for an existing approximately 273 square foot shed, required 35 feet to 5.4 feet in land lot 1136 of the 16th district. The property is located on the east side of Wildwood Road, north of Dewberry Trail. The Board of Zoning Appeals recommends approval of the variance, subject to the following conditions. Number 1, traffic comments. Number 2, development inspections comments. Number 3, stormwater management comments. And number 4, sewer comments. Is the applicant here for variance case V68? Del Cidio Joao D. Silva Jr.? Oh, okay. Let the record show he's here. Is there anyone here opposed to variance case V68? No. Let the record show there's no one opposed. Next case is variance case V69, Bill Smith LLC. Request a variance to reduce the stream buffer from 75 feet to 56 feet in land lot 982 of the 16th district. The property is located on the south side of Royal Oak Drive, east of Old Kent Road. The Board of Zoning Appeals recommends approval, subject to the following conditions. Number 1, traffic comments, and number 2, stormwater management comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V69? Let the record show there's no one opposed. Variance case V70, Dan Allison requests a variance to reduce the rear setback from required 25 feet to 8 feet in land lot 256 of the 16th district. The property is located on the east side of Cash Landing, north of Pete Shaw Road. The Board of Zoning Appeals recommends approval. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V70?
No.
Let the record show there's no one opposed. Variance case at V71, Robert Roy and Benita Roy request a variance to allow an accessory structure to the side of the principal building for 2 existing sheds and 1 proposed in-ground pool in land lot 97 of the First District. The property is located at the southern terminus of Sandpoint Way, south of Sandpoint Drive. The Board of Zoning Appeals recommends approval, subject to development inspections comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V71?
No.
Let the record show there's no one opposed. Variance case V72, Luke Burbank requests a variance to increase the maximum allowable impervious coverage from 35% to 39.71% in land lot 1004 of the 17th District. The property is located on the north side of Rivers Cobb Boulevard, north of Wildwood Parkway. The Board of Zoning Appeals recommends approval, subject to stormwater management comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V72? Let the record show there's no one opposed. Variance case V73, Jason McKinley requests a variance to reduce the front setback from 35 feet to 21 feet in land lot 705 of the 19th District. The property is located on the north side of Lanier Drive, west of Doyle Lane. The Board of Zoning Appeals recommends approval, subject to site plan review comments. Is the applicant present? Let the record show the applicant is here. Is there anyone here opposed to variance case V73? Okay, let the record show there's no one opposed. Variance case V76, Parent Properties Incorporated requests a variance to increase the maximum allowable impervious coverage from 80% to 84.03% in land lots 172, 173, 208, and 209 of the 20th District. The property is located on the north side of Auto Park Drive, east of Roberts Boulevard. The Board of Zoning Appeals recommends approval, subject to stormwater management comments. Is the applicant present? The applicant is present. Is there anyone here opposed to variance case V76?
No.
Let the record show there's no one opposed. And finally, variance case V77, Craig Sears requests a variance to reduce the rear setback from required 35 feet to 25 feet in land lot 55 of the First District. The property is located at the southern terminus of Andrea Point, south of Post Oak Trick Road. The Board of Zoning Appeals recommends approval. Is the applicant present? Applicant is here. Is there anyone here opposed to variance case V77? Let the record show there's no one opposed, and that completes the consent agenda, Madam Chair and Board.
Thank you. Do we have any comments or questions on any of these cases?
For case V68, I would like to recuse myself due to a conflict of interest.
Okay, thank you, Ms. Summer. Mr. Johnson, so do we vote separately, or how do we handle that? I know you did it recently, but remind me.
I believe the clerk would note that she recused herself from that, but the consent agenda is still,
We can just vote as a group on all this?
yes.
Okay. Do I have a motion to accept the consent cases?
I make a motion to accept the consent cases as it stands.
Thank you, Ms. Willis. And a motion to second?
I second it.
Second. Okay, we have a first and a second on this motion. All in favor, please vote. It passes 5-0. So, and as you folks, that you all can leave now, if you are on the consent agenda, just please do so quietly so we can get back to the next agenda item. Thank you for coming. Okay. We are now ready to proceed with our regular case agenda.
Okay. Next case we're going to hear is variance case V74, Rudolph L. Frampton. Request a variance to reduce the side setback from required 10 feet to 5.8 feet adjacent to the south property line, which is existing in land lot 659 of the 16th District. Property is located on the west side of Woodridge Drive, north of Ketchum Drive. Is the applicant present? The director show the applicant is here. Is there anyone here opposed to variance case V74? Got one? Okay, let the record show there's one person opposed. All those who wish to address the board, please come forward to be sworn in.
The procedure now will be that both the applicant and opposition have 10 minutes each to present their case. All testimony will be made from the podium to my right, where we have the AB capabilities. Testimony will be followed by questions from the board and may be directed at either party. Once we have closed the hearing, there can be no more further comments from the parties involved unless requested by a member of the board. So at this point, we'd like you to come to the podium.
Okay. Good afternoon, everyone. Thanks for.
Sir.
Oh, there's not yet. Thank you. Good afternoon. Thanks for the opportunity to, consider my request for variance. The reason I requested a variance is concerning this property I bought in 2008. And the house was built in the 60s. And my understanding at the time when I purchased the property was that there was nothing that was not in accordance with code. I thought I was buying a property that had everything was straight. It went through lawyers, everything. Recently, I found out that it has a substandard offset on one side of the property that varies. It's supposed to be 10 feet based on new code. And granted that this house was built before the code was developed. Anyway, the code now is 10 feet, and it varies between 5.8 to something like 7 feet. So it's not a major deviation from the code. However, since I found that out, I would like to make sure that my property is legal. If one day I wanted to sell the house or something, I didn't have an issue. So it's very simple request, and I think there's not much to it. It's just an offset that's slightly deviated from the new code. The house was built before the code was implemented, and I'm just trying to get my property legal or in accordance with your code. So that's why I made the request.
Do you have anything else?
Nothing else.
Okay, thank you. You may take a seat for now.
Thank you.
Madam Chair, make sure we get his name on the record.
Oh,
I just want to make sure that we
you're
have
not
that
here.
clearly.
Come back up to there and repeat it while you're. Yeah.
Rudolph Frampton, Rudolph Louis Frampton. I'm a civil engineer in Cobb County. Just to add to it,
Yeah.
law-abiding citizen. I think I do good in the community. I've invested a lot in the community, and I know I have opposition to me getting this variance, but I think that there's no reason that I can see why I would not get this variance. And it's not that I have done anything in the community that's not been good. I've been paying all my taxes. I keep my places clean. I cut my grass. I do everything. So I don't understand what the opposition is all about, but that's all I have to say.
Right. Thank you.
Thank you.
You may come to the podium and
Good
please-
afternoon.
Yeah, please state your name.
I'm Carolyn Rowe. I live on Woodridge in my home for 30 years, directly across from this home. And I have pictures. Is that allowable
Yes.
here? This is the neighborhood from where Mr. Frampton lives now. He did own the house next door to me for several years. We weren't buddies or anything, but he now lives up the hill and also bought this house across the street. Taking care of all the elderly people. But anyway, he sold the house next door to me. I'm telling you this because there is a history of abuse problems that, hurt me personally, cost me tens of thousands of dollars. The people that bought it, and he totally knew what was going on, a lawyer and a real estate agent. They turned the house into a duplex, 2 more driveways, two sidewalks, and my roof line was at their basement floor line. I mean, I won't get into the problems, but it was massive.
Just a
And
question.
it went on for 10 years.
Is this related to his request?
Honey, I'm sorry,
Please.
I must be deaf. I can't.
Is this related to the request he's making for his
It is
setback?
because he said this is a simple request. There is nothing simple about it. You know, we already have one of these new houses. All these houses are brick. You could build furniture out of the wood. I went with my inspector, and I have added and put my whole inheritance into my home. And it's really saddening to see, you know, these houses, they must be giving away white paint, I swear. You know, just to see them squeezed in between two, you know, our brick homes. Mr. Rudolph talked of, Frampton, of the little house, you know, in between the one where they're going to, and I'll show you pictures of what they're going to try to take down. Magnolias, oaks. I mean, it's one of the last green spaces. There we go. I know it's probably hard to tell, but actually I have pictures. And it's nothing simple about it. I mean, during construction, the homes are just not, I don't understand why builders would not want to at least add some color, maybe a little brick, and have a little more conformity to, you know, a neighborhood that is old and established, very established. People are coming in and, you know, refinishing the brick homes, adding swimming pools, and just doing wonderful things. And I've already spoken with, and I emailed Alice, I'm sorry, I don't know how to pronounce her last name, and most of the neighborhood that I spoke with is, you know, mortified that they're going to squeeze another one of these houses in between. There's also a situation with the, and they've been hiding this, you know, absolutely. I saw people first, how I found out, this was just weeks ago, they've evidently, been working on it for, you know, maybe 6 months, maybe, I don't know, but it was hidden from us intentionally. I saw markings on the street, and I asked Vance, his good friend, that, you know, rents the house in question with the variance, and I would like to show you that, the abuse of that. Now, they cleaned it up finally, because we, you know, code enforcement got onto them about all the cars, and I'll show you what it looked like at the worst point time. And I get along with them, you know. I don't want to not get along with everyone. I mean, it just hurts, you know. Anyway, and I asked Vance, his friend, what is going on, and they told me, you know, covered it up. Absolutely covered it up. She said something about, well, it'll probably raise the taxes, something about the sewer, and, you know, so I'm being lied to. And also just this last week, you know, I'm finding this out, and I spoke with the real estate agent on the sign and let him know, you know, I'm out front about it. I'm not in agreement with this at all. You know, I would help them if they need some design sense, but let's see, what am I trying to say? Losing my train of thought here. It's just wrong. Lester Maddox, the first house that was built in this neighborhood, Larry Maddox, Lester Maddox's son, is a builder and bought the house next door to me. That was an acre, but they did some weird things. You know, it's on-the-job training for me. They squeezed the house in, but this was the house that they put in, much more inconducive to the neighborhood. I was a little miffed at the fact that they had to deed half of the backyard next door to me now belongs to the house, the new house 2 houses down, plus the side property line goes off at an angle. Pretty soon we'll be doing smiley faces, you know, as property lines. Anyway, I'm just totally opposed, and I could get some assistance with this from the whole neighborhood. And I'm sorry, Mr. Frampton, you know, if this is upsetting, and the builder, I'm sure, is ready to make his money. You know, there were 2 other houses as you pull in the neighborhood. There are 3 streets here, and luckily they're, you know, not in the area. You know, Canton Road is just traffic is unbelievable, and people are cutting into our neighborhood to cut through to Piedmont and go to Town Center. But, you know, I just was really blessed the day I got into my home. And if y'all are even thinking about allowing this, because he can't go forward and probably would not have a reason to, you know, sell that property. I mean, he's done it all hiding. I didn't tell you, there were people out there at midnight this last week, you know, at midnight, using their headlights to measure. You know, they're hiding everything. And that's just not right. I'm open with everything, and I'm an open book. But, you know, if you're thinking about approving this, I would like a postponement so I can get input from the whole neighborhood. Because there are people that, you know, have opinions on this that I've spoken to, but some of them travel. The two houses right next to the house that they're trying to add in are out of town and travel quite a bit. Some are at work, so I have to catch them at night. Plus, I'm not in great shape. I'm kind of living with a temporary knee replacement. Don't go there if you're thinking about doing knee replacement. You know, save yourself. But, Your Honors, there's probably a lot more I could tell you, but there is a history of literally causing a blight, I would consider it, you know, in the neighborhood. And I'm, you know, adamant about this. If I had a lawyer to help talk for me, I could afford it, I would do that, because that's how important it is to me. And I thank you for your time.
Thank you, ma'am. You may be seated.
I'm sorry, I'm not hearing you.
Please, thank you.
What'd you say? Okay, thank you, Your Honors. Oh. Yeah, I had more to show, but whatever.
This is your,
Would the applicant please come forward? I don't think he had any signatures. Hello.
Hi.
So tell us about the house, and is it a duplex?
No, so almost 100% of what Ms. Rose said has nothing to do with my application for variance for the offset. She's talking about issues that she has in the neighborhood, and you know, since she's brought up history, I moved into the neighborhood when I first moved to Georgia 24 years ago, and I bought a house next to her. And from the moment I bought the house, it was a problem with her. And I was the type of guy that would bend over backwards because that's how my mother raised me. She's an elderly woman. I had respect for her. I would plant a hedge on my property. She would say, it's too close. I would move it. I would try to cut a tree on my land that was endangering my family. She would be mad at me. I would leave it alone. So I kept bending over backwards for her for many, many, many years. And then a property went for sale. That same property, eventually I moved from that house and bought another house just across the street just to get away from her. And I sold that house. That's what she's talking about. I sold the house to a lady that I didn't know, a real estate agent. She says I knew that the lady was going to have problems with her. How could I have known that? I sold the house for a real estate agent. So she had problems with the new people that bought my previous house, and because that's what she does. So, but she blames me for her problems with this new homeowner because she said I knew and I shouldn't have sold it to them. Well, that's unrealistic. I put the house for sale for an agent. So that's that part of that subject. Then in 2008 in the recession, a house went for sale. That same house in question, across the street from her. And the people that owned the house were good friends of mine. I actually would visit the elderly lady all the time, spend time with her. And she ended up passing away, and her son asked me if I was interested in the house. So I said, sure. I bought the house from him, so as an investment. And unknowing to me that the offset wasn't meeting the present code. So the house that's in question, I'll bring this up even if it has nothing to do with the request I'm making. The request I'm making is for an offset. But the reason I found out about it is because the property has 1.5 lots. And a contractor approached me to buy that half lot to join to another half lot so that he could get a full lot to build. They've already built one house, which I think she showed pictures of. So in the process of trying to get that sale done, I found out about this offset. So all of this about the contractor, she doesn't like the color of the house, the trees getting cut down, has nothing to do with what I'm requesting today, which is for the offset. Because regardless to if I sell land or not, I still want to get my property legal. So that's what's in question today, is that offset. It has nothing to do with she not liking the new houses, she's not liking trees getting cut, or, and I have never been abusive to her. I heard the word abuse being flown out there and stuff like that. I've always bent backwards for her. It came to a point where I realized bending over backwards wasn't going to do anything, so I just started avoiding her. I never spoke to her, and my wife told me I should go tell her that I was going to put out this variance sign. And I said, I don't think it's going to accomplish any good. I went to her house a few weeks ago. She's talking about everything is in secret. Nothing is in secret. I went to her house and I said, Carolyn, she even spoke to me very nice, asked me about my kids, everything. I went to her house. I said, Carolyn, I don't want you to panic. There's going to be a variance sign outside the house. I'm going to put it out in a couple weeks. Don't panic. It's not that I'm going to build a parking deck or anything here. I just need to get an approval of an offset to my property. So she started talking about the same kind of stuff. I don't like the color of the houses they're building. I don't like how they look. They don't have a window on one side. They're very ugly. They're cutting trees. I said, Carolyn, this has nothing to do with all that. So I left thinking that, okay, well, that went better than I thought. And then soon after, I'm getting calls saying she's talking to neighbors, telling them all sorts of things about me that are not true. And, and she said she was going to fight me tooth and nail. So I said, okay, let her do what she's got to do, but I have to do what I do. I don't think that I've done anything unreasonable. As I said before, I've been a really good citizen since I moved to Georgia. I pay a lot of,
I'm sorry, I don't mean to stop you. You were able to, I think, rebut what the opposition said. Ms. Summer-Hour, did you have additional questions that you wanted to? You did have your variance application or your variance sign posted for the 30 days?
Yeah, for the month.
And were you able to talk with any of the surrounding neighbors and get approval or an understanding from them? Were you able to get signatures at all?
I got all the signatures. I gave them to Mr. Scott. I got all the signatures from the property. None of the property owners adjoining me had any issues with it. They all signed.
Thank you.
Where are those signatures?
And the other thing about this whole thing about this was done in secret, there's a real estate agent sign has been out front of the property for months now. So I don't know what's the secret. If it was secret, there wouldn't be a big sign up front. So
One quick question for clarification. In looking at the lot, just to understand, if I'm facing the house, is your encroachment to the right, to the left?
if you're looking at the house, it's to the left.
Okay, thank you.
You're
Just
welcome.
wanted to be sure I was looking at it correctly.
Yes.
Can we ask them to sit or until?
I would like to see the signatures.
Okay. Why don't you take a seat from, oh, you do, go ahead, I'm sorry.
Should I sit?
No.
No, I have a question. So when you bought this house, was this garage already
Yeah,
here?
that's exactly how the house was built in the 60s. The brick, everything is the same.
Okay,
There has been no modification to the house, none at all.
so Mr. Peterson, in the development inspections, they said if this variance is approved, the structure will need to be permitted and inspected. So if this has been existing since he purchased the house, and I believe, I don't know how long this has been like this, will he have to go get this garage permitted?
No,
No,
that comment's really meant for a proposed new addition. If this is existing, then that comment would not apply.
So this is, you're not asking for any proposed new additions to this house?
No, that's why I said it was a simple request. This house is exactly how it was built in the 60s.
So then
It's
that-
not like I went and added to the garage, or I could understand that. If I went and add to the garage, I could understand that somebody being upset about that. But this is just an offset from when the building was built to the boundary line. The
Okay, I
neighbor-
understand.
the-
It's just confusing as the comment that we have from the different departments. It appears like you are going to go build something.
No.
And in doing that. So we could strike that from, okay. It's just
What they
confusing.
might be talking about is that half lot on the other side that I was talking about, that the contractor wants to buy from me to join to another half lot to make a complete lot.
So
to
then from
build.
the right side of this home,
Yes.
a developer's coming in to ask you to sell. Part-
We've already been talking. He was at the county getting ready to close the deal when they said, you got to take care of this offset. I have to take care of the offset before I can sell. They were good with everything. It's just that I had to get a variance for that offset before I could sell.
So in the offset, though, you're selling to what would be an established property line?
No,
Because,
no, the portion of land that I would be selling is on the opposite side of the property. So when I bought the property, it was 1.5 lots. So each lot in that area has a typical frontage of 100 feet. So I bought 150 feet. It was 1.5. So when I bought the property, it was 2 lots. I just combined it. Now that the contractor came to me, I'm proposing to sell him, or he's requesting, I think it's 47 feet. So I end up with a little more than the typical 100 feet on that existing house, like 104 or something, like 103.
so you would have to go then, and if you do sell it, to get this replatted?
They did that already. It's all surveyed, they did the plots, everything. When they were about to finalize with the county, that's when they saw that I didn't have the offset on the other side per code. So all they wait, that's the reason I had to request that variance.
Okay, thank you.
Thank you.
Do you remember roughly how many signatures you had when you gathered them?
4, I think it
4.
was.
It's 4.
4, yeah.
All right, do any commissioners have any further questions?
No, I'm good.
All right,
Thank you.
You can have a seat.
Thank you.
Any discussion regarding this case?
No, I'm clear now that I understand.
Okay. I would like to make a motion to approve V74 with staff comments.
Can we omit development inspections because it doesn't really pertain to this?
Yes.
Okay.
You want to restate your motion?
Would like to approve V74 subject to staff comments, except not including development inspections.
I second it.
I'll place your votes.
Hey,
What?
may I say one thing?
Yes.
There really are no staff comments except for that one comment. So
Okay.
we don't need to add any staff comments to it.
Okay.
Okay, do we restate it?
Yeah, we need to restate the motion.
Okay.
Approve V74,
Period.
That's it.
Without staff comments.
Yes, all right.
Second.
Do we need to second that one? Yes. You're seconding? Thank you.
Second.
So do you want to clear the screen? Yeah, reset the board. Thank you. Now place your votes, please.
No, it doesn't work.
It's, okay. All right. The request passes 5-0. Thank you very much. This concludes what?
That completes the printed agenda for your variance hearing.
Yes.
You do have an appeal hearing that will follow this when you're finished, so it's up to you whether you want to keep going or take a small break.
Yes. Well, we haven't done a few other housekeeping
Okay.
And yes, we'll take a brief break after we wrap this. All right. Back to the homework, guys. Do we have? Yeah. Do I have a motion to approve the minutes from the variance hearing on June 14th and the special call meeting on July 10th? Need a motion stating that, please?
So moved.
Who made the motion? Ms. Willis? Hmm?
Me.
Okay. Ms. Summer, second.
Second.
Ms. Willis? All in favor? Now, do I have a motion to adjourn, please?
I make a motion to adjourn.
I second. I beat you.
Please place your votes. Thank you. We are now adjourned, and we will take a 15-minute break before we begin our our hearing regarding a notice of violation issued by Cobb County. Good afternoon. We are here today to hear the appeal of Ryan Cunningham as to the notice of violation issued by Cobb County Code Enforcement Inspector Jason Cochran on April 28, 2023. The notice states that Mr. Cunningham's property is in violation of Cobb County Code Section 83-12 related to the allowable height of grass and weeds. At this point, I will turn this over to Debbie Blair, the hearing officer.
Good afternoon. I'm Debbie Blair with the County Attorney's Office, and I'll be the hearing officer today. The hearing today will be conducted as follows. Each party will have an opportunity to make an opening statement, about 3 minutes, and then Mr. Cunningham will present his case, which he has a total of 20 minutes to present, and then Mr. Johnson will present the county's case, again, with a 20-minute time limit. Following the presentation of both sides, they will have an opportunity for a closing statement. And at that point in time, you all can ask any questions. If there are any witnesses presented, you can ask questions of the witnesses as well. You will hear the evidence, and then you'll have an opportunity to make a ruling today, or if you feel that you need more information, then you will set a time which you would make that decision after you receive that additional information. But more than likely, you'll be able to make a ruling today. Any questions? I will call Mr. Cunningham. If you'll come and make your opening statement, please.
Hello, I'm Ryan Cunningham. I'm here today to express my concerns in opposition to the code violations, section 83-12, which imposes fines for grass and weeds exceeding 12 inches in height. As a resident living in a non-HOA neighborhood surrounded by a forest, I have recently built a house and wish to restore the natural landscape that was once there. In order to achieve this, I believe it necessary to allow my yard to grow without fear of being fined. Firstly, I would like to highlight the importance of preserving and restoring a natural ecosystem. We are increasingly recognizing the ecological benefits of maintaining native plants and allowing natural landscapes to flourish. Native grasses and plants support local biodiversity by providing habitats for various species of wildlife, including birds, insects, and pollinators. The reduction of such natural spaces in urban areas has led to the decline of many native species. Secondarily, the enforcement of section 83-12 disproportionately affects the residents like myself who living in non-HOA neighborhoods. Homeowners governed by HOA can appeal their grievances without a special meeting to do so, while those in non-HOA neighborhoods often face restrictions imposed by municipal codes requiring a vast amount of local government resources. It is crucial to ensure a fair treatment, equal rights for all residents, regardless of the type of neighborhood that we live in. Granting homeowners in non-HOA neighborhoods to freedom to restore the natural landscapes would promote a presence of autonomy and provide pride in their properties without compromising the overall aesthetic appeal of the community. Moreover, it's important to consider potential economic benefits that can arise from embracing a natural landscape. Natural landscapes require less maintenance for pesticides and minimal watering compared to manicured lawns. This can result in significant cost savings for homeowners, as well as reduced strain on local water supply and decreased reliance on chemical fertilizers, and encouraging natural landscapes practices that can contribute to more sustainable and economical community. I kindly request the Cobb County Board to reconsider and amend code section 83-12 to accommodate homeowners who wish to restore their natural landscapes. Possible alternatives could include exemptions for properties surrounded by forests, the establishment of guidelines for maintaining natural gardens that ensure safety and prevent nuisance for neighboring properties. These modifications would allow residents like myself to restore the native environment without fear of facing fines or penalties. I appreciate your attention to this matter and thank you for considering my perspective.
Thank you.
Did you have, Mr. Cunningham, did you have anything further to add?
I thought that was supposed to be just the opening.
Yeah, and that's, I just wanted to make sure.
No, I'm good. That's it.
Okay. Mr. Johnson, would you like to make your opening?
I go away.
You can have a seat, please.
Good afternoon, Chairman and members. My name is Brian Johnson on behalf of Cobb County Code Enforcement. Here today to ask this board to uphold code enforcement's decision to issue notice of violation to Ryan Cunningham for failing to maintain his property located at 2875 Loring Road in compliance with Section 8312 of the official code of Cobb County, Georgia. In this appeal, the board must determine whether an error was committed by code enforcement for the issuance of the notice of violation. The burden is on the property owner to show that the condition of the property does not constitute a public nuisance, meaning that the property is in compliance with the code. The weed control ordinance was adopted by the Cobb County Board of Commissioners under their police power, and this police power is delegated to counties via Georgia law, which provides that each county may adopt ordinances for the purpose of protecting, preserving public health, safety, and the welfare of its citizenry. Cobb County Code, Section 8312 states, it shall be unlawful for the owner of any property that contains an easement or property in their, on their subject property to permit weeds to obtain a height exceeding 12 inches on any portion of the property unless exempted. This language of the code is clear and unambiguous. Properties in Cobb County must be maintained at a height of 12 inches or less. Later, you will see photographs that clearly show that the property is not in compliance with Cobb County Code, and therefore, as defined by the Cobb County Board of Commissioners, constitutes a public nuisance. The property owner is responsible for the entire lot, and the fact that the owner of the parcel says that it's the intent to allow for natural landscape does not mitigate the violation or the need to maintain the property as required by code. We ask you to find the property as being improperly maintained in violation of Cobb County Code, and that you will uphold the notice of the issuance of violation as the information will later show. Thank you.
Thank you, Mr. Johnson. Mr. Cunningham, if you would come up and present your case in Maine, please.
Hi, Ryan Cunningham. So, where do I start? First, I wanted to specifically show, all right, so all the areas I have highlighted are in blue will be the areas that are forested. The area in yellow in this picture will be the show our property, maybe. So, essentially, on all sides, minus our neighbors, they're the only ones that don't have just a completely, forested area. Let's see. Secondarily, the areas that we've highlighted on this picture are plots that we've already obtained natural plants from, native plants from the forestry department. And we've replanted them along those edges. The circles are the trees, and the red outline is a mulched area for local flowers and everything else. Let's see. Next, we're showing the plot that's kind of in question, where the red and blue arrows are is kind of the approximate area where the sewer easement is. So essentially, I know that the easement is not allowed to have any trees growing on it or whatever. However, I don't know what the requirement is for upkeep when there is a forest next to it. Am I required to basically upkeep the property even though that there was trees there before construction? that we had to remove in order to gain access to the property. So that's the biggest thing, is that we would like to be able to retain it to its natural, perspective. And there were trees there before. Let's see. Moving to a different perspective here. I'm not exactly sure where this particular line came from, but it says Cunningham claims he, the side of the yard along Pine Mountain Road is too steep for mowing. I don't live around Pine Mountain Road, and there's no Pine Mountain Road near me. Regardless of that, the only hill that I have is on the front, and I mow it. So I don't know exactly what that particular statement is referring to in this. Next. Picture is basically to the left side of the house and what that area looks like. So essentially 10 feet off of our property line easement, this is what happens. And we're not, no one is maintaining this. So my question being is, why is my yard obviously within this, code when we have all the natural forested area that's growing as it should be? Let's see. Next. Same idea, except that's my neighbor's yard. I'm assuming that he also got a letter in the mail too, but similarly, he has weeds that are growing around the outside edge. Past this point, his yard actually turns into almost a swamp. So which is not maintained at all. So this was me taking pictures of some of the plants that we have growing. This is a sunflower, not a weed, and obviously it is over 24 inches. My question is how do we discern between a plant that's going to have a flower on it that we have planted on purpose versus what we would consider a weed? So I have a couple other ones too. So basically that is I believe a yellow pine, if I remember right. No, can't remember the name. Anyways, this is one of the trees that we got from the forestry department. So, and we do have a significant amount of the trees surrounded by mulch, the ones that lived anyways. But we did get a significant portion of the trees don't, because the forestry department just decided to give us the rest of their trees for the year for whatever reason. So we ended up with 150 something trees. So anyway, so we just said, well, we'll just plant them and see what happens. So these are the ones that grew more so than the rest, but we still have a significant amount of trees that are there. So more of the same, but just this is on the side yard. These are creek myrtles, no, dogwoods, I'm sorry, dogwoods. So we planted those specifically so for root control of the pine trees there. So anyways, we are trying to restore the area around us as best we can. So this one, these are the wildflowers that we planted. The interior portion of our house contains a courtyard. I'm assuming that that is also not going to be against the code. I don't know how you do courtyards, but anyways, so the natural height of what the wildflowers tend to grow before that they gain a flower is about anywhere between 6 to 12 inches at least. So that's my major issue, is that although the plants look ugly beforehand, eventually they gain a flower. Secondarily, our assumed culprit, the weed in question. So this guy, I assume, is the problem of our yard that grows very quickly. And as I have shown here, that I am obviously violating the code. But anyways, so this guy is the one that I'm assuming that whoever called us in is having an issue with. So it takes about 2 days after it rains for our yard to dry completely. So it's just clay. So can't even get the lawnmower in order to chug through it if I wanted to. So anyways, in those 2 days, those weeds will inhibit our yard quite quickly. Do my best in order to trim them as I can, but basically what I wanted to make sure of is that within a reasonable amount of time, if someone from code enforcement comes by, that, you know, I'm not going to end up with a $250 fine for having, you know, a few weeds out of question. So, and the rest of the grass we're still trying to get to propagate, and we have lots of different species of clover trying to get the yard to germinate and fill that area in. So eventually we won't even have this problem because the trees and everything will take over, but it takes time. In this case, I wanted to actually cite one of the, let's see. So in the, I guess, the letter I received in the mail, it's cited a case for Parker versus City of Glenville. In that one, it actually gives a definition for what a weed is, I suppose. It says it shall be unlawful for any owner or resident of any lot, area, or place located within this city to permit any weeds, grass, or unhealthy growths to obtain a height exceeding 10 inches on such property. For purposes of this section, the term weeds shall be deemed to mean, and I'll let you all read the short list, but at the very end, it says, or other unsightly growths of a like kind. Yeah. So basically, the plant that I showed prior, the weed in question, is not on the short list. And really, the list that is there, I know it is supposed to be kind of a thing that's just saying don't grow, you know, whatever that is what we don't like. Just things that we don't like, basically. But my point being is that that is not an objective term. It's like the only objective or measurable term from the ordinance is the 12 inches. But
Mr. Cunningham, where is this from?
It's the paper that we got in the mail, so is it? I'll find it. Positions paper. Cobb County's positions paper. This was the.
Okay, thank you.
So I went and just briefly went over all the statutes to see what refers to as a weed, basically. Because, and my point being, though, is that the code is very much saying that anything anything over 12 inches is just not, is considered a illegal plant, basically. That's not necessarily an objective thing. So the definitions that we have here, it's a short list, which you can't go into every single plant. I get it. That's fine. So, but as for, it's kind of a homeowner's discretion on what considered a unsightly growth, because someone's unsightly growth could be someone's, beauty. So, anyways, let's see if I have one more point. All right. So the intent of the code is that basically you're not supposed to have your yard over 12 inches in order to not harbor any sort of unwanted rodents, insects, whatever. However, there's no way that my yard is going to harbor anything more than what the surrounding area is going to do. So, considering that we live in a forest. So, secondarily, we had the lowest property values. Well, most of the entire neighborhood is, as I've shown, covered in trees anyways. So if anything, we're matching the aesthetic of the neighborhood. Let's see. So the next thing would be the clarifications for the side yard. So instead, we said, due to the intent of our yard, i.e. return to the forest, we would like to have our yard deemed as a natural area and let it return to the forest state as the surrounding area. Additionally, the side yard is a part of the sewer easement, and since the easement of the private property in order to install, expand, or maintain utilities, it appears that our yard is exempt from this code. Site plant showing easement in the attached, which I have a little blurb there. Okay. And that's kind of my general argument here. So, and I just want to see that basically we want to be able to return our lot into what it was before, just with the house in the middle. And I would like to be able to do it without having a general fear of being fined. And I don't necessarily care if if I have to follow the enforcement. I more so need guidelines on what it takes to make sure that I don't end up here every, few months, basically, trying to fight the same thing. So we need to have, I guess, clarification on what counts as a, planted area versus, or plant versus what considered to be a weed. That would be one helpful thing, because as I said, we have wildflowers, planted wildflowers growing. So, and we have not planted any trees along the sewer easement, as we already knew that was a no-no. However, we do have wildflowers growing back there. Actually, most of those are naturally growing. So they just decided that one day, didn't have anything to do with it. So, but anyways, they're very pretty. I would like to not cut them down. So it was like, unless you'll have to do maintenance, then I understand. So, because I like my sewer. So, and I don't want to have to get a, whatchamacallit, I can't even think of it. Yeah, septic tank. I was like, my yard doesn't perk very well. So, but anyways, that's what I have. So thank you for your time.
Mr. Cunningham, you have 2 minutes remaining if you want to make any comments after Mr. Johnson speaks.
Members of the Board of Zoning Appeals, I'm going to go through a quick PowerPoint, so some information to you, then I'll call a witness up to testify. This matter involves Mr. Cunningham's appeal of the notice of violation in violation of the weed control ordinance, and this is an area which I think we have already seen as well. Police power is granted to Cobb County to craft and enforce ordinances which promote the welfare of its citizenry. The state of Georgia has granted the county that authority. The Cobb County Code is clear, as adopted by the Board of Commissioners, that it's unlawful for the owner to permit weeds to obtain a height exceeding 12 inches. This language is clear and unambiguous. Here are some pictures from the date of the notice of violation from the yard in question, as previously explained by Mr. Cunningham. The pictures speak for themselves, that whether or not there is intent or attempt to grow some flowers, that grass and weeds are in excess of 12 inches of height. We're going to ask this board to uphold the decision to issue the notice of violation. And at this time, I'd like to call up Brent Farrell, who is the Code Enforcement Division Manager, to provide some testimony. Please state your name and your name and position with the county.
My name is Brent Farrell. I'm the Code Enforcement Division Manager.
And how long have you worked with Cobb County?
Since 2005.
And have you worked in the same capacity with the county?
No, I started with animal control in 2005, and I moved to code enforcement in 2013.
So what are some of your duties as Code Enforcement Manager?
Overseeing the day-to-day operations, scheduling, training, hiring new officers for the Code Enforcement Division.
I'm going to hand you what will be marked as Exhibit 1, which is the ordinance, certified copy of the county ordinance. Are you familiar with what is shown in this document?
Yes.
And what is this that you're
This
looking at?
is the Chapter 83 for the weed control ordinance.
Okay. I would like to this time to tender a certified copy of the weed control ordinance. How does code enforcement learn of potential violations throughout the county?
Generally, we receive complaints from citizens via phone calls, emails. Sometimes they come in the office in person. Sometimes an officer in the field will get flagged down to file a complaint.
And what type of information is collected and gathered by staff when a complaint is made?
We ask what the nature of the complaint is, if they can give us specific as to the location on the property, and then the address that the violation is allegedly occurring at.
Are all complaints investigated by code enforcement staff?
Unless it's something that we don't have authority to enforce, we would send it to the proper division, but anything that we have authority, we will inspect.
Section 8312 details the prohibited activity. Can you describe what is prohibited under that code section?
For grass and weeds to obtain a height over 12 inches.
Have you reviewed this case file for 2875 Loring Road?
I have.
I'm going to hand you what is being marked as Exhibit 2. Are you familiar with this document?
Yes.
Can you say what this document is for the record?
This is a standard notice of violation that would be issued for a grass and weeds violation.
And who prepared this report?
Jason Cochran.
And who is he?
He is a code enforcement officer.
Is this the type of report or document that is kept in the regular course of business?
Yes.
Is it regular practice for staff to prepare such report?
Yes.
At this time, I'd like to tender it into evidence. And when was the first time that code enforcement issued a notice of violation for this property?
April 28th of 2023.
At that time, I believe the notice of violation was issued and subsequent pictures were taken, and I'd like to provide them for your review. Are you familiar with these pictures?
Yes, these are the photos that were taken after we received the appeal notice.
I'd like to enter these into evidence. Do we need to show these?
Yeah, if you would, please show those.
Okay. Some of these have been provided to you already and were on the PowerPoint, but we'll show them again. And I'll get Mr. Farrell to explain them as they're described, depicted.
Okay, so this would be, if you were facing from the street, the left side of the driveway. There's some overgrown grass in there. There are some plants in there, the ones that the mulch is planted around. Those would not be the issue, but grass and weeds, in between and around those. And then this is the right side of the house if you're facing it from the street. This was the most overgrown portion of the property. And this, I believe, is looking towards the street near the front door. I'm not certain on that one, but the front yard, the entire front yard was in compliance at the time. And that's, more of the same. That's the front yard area, kind of next to the driveway. That area also was in compliance.
And I believe you have additional pictures
Yes,
as
these
well.
were taken today.
Okay, so these are taken today. I'm going to ask for these to be depicted as well, and then I will enter them as evidence collectively as Exhibit 8, I believe.
Okay, and this is the front yard from the street. Looking at the pictures, it doesn't look like the grass is over 12 inches, so I don't believe that portion is in violation. And this is the left side of the driveway from the street. Some of the grass and weeds in that area are over 12 inches. And that's just a closer view of the grass in the front yard. And that is the right side of the property facing from the street.
Thank you. Hand these. I don't have exhibit stickers on them, so I have to do that. Okay. Also, at this time, I'd like to tender into evidence position paper of Cobb County on behalf of Code Enforcement as Exhibit 7. And finally, Mr. Farrell, in your assessment on the date of the notice of violation, the property was not in compliance with Cobb County Code.
Correct.
And as depicted in the pictures presented here today, the property in portion does not remain in compliance with Cobb County Code.
Correct.
But on the date in question, at the notice of violation, in your opinion, it was not in compliance.
Correct.
Thank you.
Mr. Cunningham, did you have any questions that you wanted to ask of Mr. Farrell? Pardon me?
Honestly, I just wanted to say that was beneficial because I have no idea which parts of the yard were in compliance. compliance of which one, so. Thank you.
Okay.
That is all for the county right now.
Would either party like to make any final closing statement before the board asks any questions or deliberates? Oh, okay, sorry.
Once again, thank you for your time and attention this afternoon. The evidence presented shows that 2875 at the date of the notice of violation was not in compliance and was in violation of Cobb County Code. The property owners failed to meet their burden to show that it was maintained or is being maintained, regardless of the intent or the goals. If the weeds and the grass are greater than 12 inches, it's in violation of Cobb County Code. And code enforcement manager stated that the code enforcement officer made that determination at that time when the notice of violation was given. There was nothing arbitrary in issuing that notice of violation on that date. We ask you find this property as being improperly maintained in violation of Cobb County Code at this time. Thank you.
And before I turn it over to you to ask any questions, I just want to state that the standard today is whether or not there was an abuse of discretion on the part of the inspector. So what you're looking at is analyzing the evidence that was submitted today, the photographs and the commentary, and determining whether or not the code enforcement inspector had any evidence before him when he issued the notice of violation, that there was a violation of Code 83-12. Do y'all have any questions on the standard? And I turn it over to y'all.
Ms. Blair, should we leave our mics on or off to discuss, if we want to discuss among ourselves?
You'll call on your...
Okay,
You'll call on everyone as you normally do.
okay. Does anyone have questions? Of course you do.
Thank you, Madam Chair. Let me start with Mr. Farrell. So we've received a definition today of what a weed is pursuant to a case cited by Mr. Cunningham. And that is, he defines it per the Parker versus City of Glenville as being, if I'm pronouncing these right, gypsum, burdock, cockabur, dandelion, or like kind unsightly growth. That's how the case that he put up defines weeds. Do you know for certain whether any of those things are present on this property?
I can't say.
Okay. So what he did say also, though, was that certain sunflowers that grow on the property, that they appear to be unsightly weeds until such time as they ultimately bear a flower. You heard that from
Yes.
him? Okay. What's your thought is, well, let me say also, I looked, just asked a little question of my handheld device, what is a weed, or is grass a weed? I looked into both of those questions, and it seemed to suggest the weed's anything you don't want growing in your yard.
Right.
That's the way some people think of it or define it. But here, it really doesn't matter whether we define grass as a weed, right? It's either one.
Yeah, well, grass is defined as a weed, but things like flowers, sunflowers, things that are purposefully planted, we would not require those to be trimmed.
Okay. So let's go back. It looks to me like there was some notice of violation given, correct?
Yes.
And the date the notice of violation was given, is it April 28th or was it sooner?
April 28th of this year was the date the notice of violation was issued.
So then he was to have 20 calendar days to correct the situation, and it sounds like today, rather than try to correct it in full, the solution is to challenge the ordinance. But did anybody go back out 20 calendar days later?
We went out on the 18th of May just to take the photos because that was after we received the appeal. But when we do receive those appeals, we hold enforcement in abeyance until that hearing is concluded.
I see. Okay. And per these photos on May 18th, is it clear that you believe that they show that there are weeds more than 12 inches tall?
Yes.
And these are in the front of the property, not merely in the side of the property?
Primarily on the sides, not, the front yard was not in violation. The small strip on the left side of the driveway and then on the right side of the house is where the violation areas were.
Okay. Do you know whether the house is in a platted subdivision?
I don't believe so, but I don't have that information.
Do you know what the size of the lot is where the house is located?
I do not.
Do you know whether the county affords any process that allows the homeowner, if he wishes to redefine the contours of his yard so as to create additional wooded area, allows him to obtain a variance or otherwise work with the county towards augmenting the wooded area near his house?
I'm not certain, I don't have any knowledge of something that would allow something like that. Generally, when a lot is developed, when the lot's developed, there's a defined yard area that, we, in our opinion, should be maintained because it is no longer a natural area.
Do you know if there's any minimum lot area between a wooded area and a structure?
Not that I'm aware of.
Those are all the questions I have of this gentleman. Any of my fellow board members have questions of him?
Did you just say the areas that were at issue were on each side of the house?
Yes.
Not the back?
The rear of the home is pretty much all woods, all naturally wooded area, so that's not in question.
Okay, so it's just the sides?
Just the sides, yes.
Okay.
So for clarification, from the back of the house, ongoing is considered wooded and is not in violation?
Yes, correct, yes. From the
I
rear
just wanted
portion of
to
the home
lie.
all the way to the back property line is all naturally wooded area.
So the real issue is, for the most part, particularly on the right side of the house?
Correct.
The other question I have for you is, how, have y'all been trained to determine various flowers that could be in a yard that would be confusing? Like the sunflower, I could name
Yeah.
a whole series of ones
So
that until they bloom, they are not.
In an
very-
event like that, we would rely on the county arborist to assist us in identifying the plants. If a homeowner makes an argument that, it's not a weed, it's a, certain type of flower or something that was planted purposefully, we would consult with the county arborist and they would generally inspect the property with us to identify the different species.
Thank you. Anybody else have a question for him?
I have other questions for other persons, if I
Okay.
can.
Go
If I
right
can
ahead,
get the, Mr. Cunningham back up.
Hello.
Hey, do you happen to know whether or not you're in a platted subdivision at all?
I believe we are not. I can give you what basically happened for this.
Okay.
Okay, so the guy that we bought it from, his name is Paul Hurley. His dad bought almost all of these plots as an investment, and anytime one of his children went broke, basically he sold a plot. So never did it all at once. And that's essentially why we back up to so many different random houses. So for instance, we have a frame at the end of the road. We have a lovely cabin 2 doors down from us, and we have this weird rhombus house on one of the corners. So definitely a plethora of
different arrays that I can't imagine that would be one architect doing.
Do you know what the precise distance is from the right-of-way in front of the home? The right-of-way line that you see here, as shown, to the front edge of the house?
The front edge, 35 feet.
Just 35 feet?
Yep.
So those are some relatively small cars out there? Like
The back, so basically the reason why our house is shaped kind of like a triangle almost, and it's, right angle, that is where I believe, 500-year floodplain is. So that is the max buildable land allowed by Cobb County.
Okay. Can you point out which line that is by reference to the what's being shown to you now?
Let's see.
You see the lighter green than the darker green
Yeah, I believe it would be
shading?
the lighter green. So, and anything that gets disturbed back behind that line, you have to basically take the dirt from that's existing and move it around in order to be in compliance. Because I think we back up to Butler Creek and we have to stay 150 feet away from Butler Creek. So that's why our house is basically this shape, minus the courtyard. That's my idea.
Okay. What's your lot size, do you know?
0.77 if I remember.
And based upon what you told me, the sides of your house, the land along the sides of your house would be within 75 feet of Loring Road's right-of-way, correct?
Mm-hmm.
Okay. Were the plantings along the side of the house or what grew naturally there allowed to stay 12 inches tall for more than 20 days in April and May of this year?
On the sides, yes.
Yes.
In the front, no. So mainly because the entire problem that I've had is I don't know exactly what was a part of the 12 inches. So is it just the fronts, the sides? What are we talking about? Especially when on the back side of the house, we back up to a forest. So I guess I know now, but.
Was the house vacant at any time in April or May of this year?
No.
Those are all the questions I have for this gentleman.
I have a few. Can you speak to your neighborhood impact? What do your neighbors say as it relates to this issue?
Currently, I know that our neighbor across the street has tried to clean up some of their area, but theirs is even worse than what ours is, because basically they have the back part of their yard is, like I said, it's a swamp. It's like there's no getting a lawnmower into it. It's like they have cattails there. So, I mean, you'd have to go put boots on in order to mow it if you wanted to. So I know that he was supposed to be filing something as well. So I know that the person, I believe there was 2 other people that had appeals as well for it. There was one where he is basically the person that was on the complaint that said his hill is too steep. What I believe he's actually referring to, because I've talked to the neighbor for this, is he means he lives on a ravine and his driveway is going down and back up, so it counts as a spot that he has to maintain and mow. However, you can barely walk up it. I mean, it's a valley, and his driveway is like a quarter mile long, so it's not a easy parcel of land that you would be able to maintain in the manner of what the ordinance suggests. So, I mean, as I said, the neighborhood aesthetic is forest, minus our neighbors, but I know that's not, we're friends with them, we're fine. It's not them that are the issue, they don't care about us, so.
Thanks for that, I appreciate it.
Not this gentleman. I need to get the county officer back for one more question. Were any part of the weeds that you observed, whether in pictures or in person, in what you describe as being in the side yard, were any of those between the house and the front of the building or structure? I mean, between the road and the front of the building or the structure. So if we define side, if you drew a line across the front of the house, were there any weeds between that line and the right-of-way?
A small portion on the left side of the driveway.
Okay. Thank you.
Does anyone else have any questions? Okay, are we prepared to make a motion at this point? Or do we need to discuss the matter further and come back together at a different time? Y'all need to tell them.
I can give some preliminary comments and
Okay.
so the standard we were given is abuse of discretion with the burden on the applicant or on the appellant to show that there's been an abuse of discretion, and the undisputed testimony appears to be that what is described as the side of the property has weeds on it that were 12 inches tall or more within the area between the right-of-way and the front of the house, even though some of that area was described by the county as being side, but it falls within the code. It seems to fall within the code as being a violation. So my thought would be that the hearing officer did not abuse his discretion in acting. But my thought is also that we should, before further citations are given, that we encourage its discussion, possibly with the county arborist, possibly having the homeowner meet with the ComDev about whether or not it would be appropriate to seek some form of a variance in order to allow him to augment his wooded areas. I say that knowing that the closer wooded areas are to a house, particularly a wood framed house, that you're increasing the likelihood for, I would think you're increasing the likelihood for termites, you're increasing the likelihood for potentially wood-boring beetles, you're increasing certain other likelihood or potential for rodents of certain kinds. So I know the county has reasons for liking yards, but it just seems that there should be, I would hope there would be some dialogue down the road. That's not what we're asked to decide today. I've indicated what I think about what we're asked to decide today, and I would just open it up to my fellow board members for their comments.
Anyone else? Are we prepared to make a motion? Okay, I'll hear the motion.
So my motion is based upon the fact that the appellant has failed to meet his burden, that we deny the appeal.
Do I have a second?
Second.
Okay, please place your votes. Thank you. It passes 5-0. Is there any other business we need to take care of? Ms. Blair?
No.
Okay. Do I have a motion for adjournment, please?
I make a motion to adjourn.
I need a second, please.
I second it.
All in favor? We are officially adjourned. Thank you very much.